I would like to welcome you. Good evening to us here in the middle of Europe. Good afternoon to those of you in the United States, or good morning to Ralph. This is the book launch for Law and Kritik, Recht und Kritik. It is the second volume in the controversial book series with Karl Alber Verlag. The volume and this evening asks, is legal critique possible during a period of autocratic legalism, polycrisis, and lawfare? And we were already starting to get into a discussion while we were warming up just a moment ago. My name is Greta Olson, and I'll be moderating this event. I'm a professor of English and American Literary and Cultural Studies and the head of the Center for Diversity, Media, and Law at the University of Gießen in Germany. Very briefly, I'm going to, in just a moment, turn over to my colleague Jochen Bung, who is a co-editor, for a short introduction in German. And then bear with us, German speakers, while much of the event, then the inputs, very kindly, particularly from Frau Gerstenberger, who wrote in German, will be in English. And then in the question and answer and commentary session, we welcome comments in German or English. We wanted to open it up. I realize this is a bit of Anglosphere monopolization, but we wished for more people to be able to participate than less. And as I mentioned, we will welcome both languages in the Q&A. Then we will look forward to inputs by Peter Goodrich, by Heide Gerstenberger, by Gerlov von Englenhoven, by Ralph Grunewald, and by Daria Bayer. And Daria, do you wish to just say hello briefly so we can see that your audio and visual is working?
Yes, thank you very much. Can you hear me?
Sounds wonderful. And okay, perfect. Thank you so much. Great that you could make it. I think you're coming from class or another event. This part of the event will be recorded, and the question and answer and comment period will not be, as we haven't gotten everyone's permission. Wonderful. I see Annette Rosenberg, many other contributors are coming in as we speak. So I'd like to first introduce my co-editor of the volume, that is Jochen Bung. He is a professor of legal philosophy and criminal law at the University of Hamburg. He is a co-editor of the controversial series. I'll be introducing the other editors in just a moment. And he's the author of a contribution in the volume called, auf Deutsch, Kritik des Rechts als Finger in der Wunde, critiquing law as putting a finger in the wound. Welcome, Jochen.
Unglaublich, es passiert immer wieder. Thank you, Greta. Ein paar Worte auf Deutsch am Anfang. Symbolisch, weil doch viele Beiträge, auch auf Deutsch, du hast es gesagt, in dem Buch enthalten sind. Ganz herzlich willkommen zur Buchpräsentation. Wir freuen uns unglaublich, dass das Buch da ist und gut aufgenommen wird. Ich bin als Mitherausgeber natürlich befangen, möchte aber doch sagen, dass ich finde, dass ein einzigartiges Buch geworden ist. Es hat länger gedauert, als wir gedacht haben. Die Grundidee war ja kurze, knackige Beiträge zur Rechtskritik, 4 bis 5 Seiten, einfach heruntergeschrieben, ohne Fußnoten. Das war die ursprüngliche Idee. Und das muss doch schnell gehen, dachten wir. Ja, aber am Ende kommen dann doch die Routinen, man will dann doch die Belege mit Referenzen unterfüttern. Und dann waren es ja schließlich auch sehr, sehr viele, die mitgemacht haben bei dem Projekt. Also die Sache hat sich einfach dann ein wenig hingezogen. Umso schöner, dass es am Ende dann doch geklappt hat. Und daran haben viele mitgewirkt, vor allem aber Greta und ihrem Team gebührt der allergrößte Dank dafür, dass das so erfolgreich abgeschlossen wurde. Inhaltlich will ich nicht viel sagen. Rechtskritik ist ein Thema, das spannend bleibt. Ich denke, es gibt die klassische Rechtskritik, die materialistische Rechtskritik, die bleibt so lange aktuell, solange sich die Verhältnisse nicht wesentlich geändert haben, aber die gesellschaftlichen und sozialen, aber die politischen Bedingungen einer kritischen Verständigung über das Recht haben sich doch gerade in letzter Zeit gewandelt. Und wenn Macht und Willkür auf der ganzen Welt sich stärker in Szene setzen und hemmungsloser in Szene setzen, gibt es vielleicht doch auch stärker das Verlangen zu schauen, also auch unter Rückgriff auf Handlungsmöglichkeiten, die das Recht zur Verfügung stellt, etwas gegen diese Enthemmungen zu tun. Die Multiperspektivität der Perspektiven, die in dem Buch aufgeworfen werden, kann ich nicht annähernd wiedergeben. Ich finde, das Buch ist eine Fundgrube der Ideen und der Inspiration. Es informiert und inspiriert. Einige dieser Ideen, Inspirationen wollen wir heute gemeinsam diskutieren. Now we are getting really started. I'll hand things over to you, Greta, and we all switch back to English.
As mentioned, this part of the event is recorded and in English, and then we'll switch to German and English in the end. Recht und Kritik, Law and Critique, is part of a series called Controversial, which is edited by, and I would be grateful if my co-editors would put their cameras on if they can, by Christian Schmidt. He is a Privatdozent of political philosophy at the Humboldt University of Berlin. By Benno Zebel, who's written me that he is also taking care of his child right now, but we love you and your child as we speak. He is a professor of philosophy of law at the University of Frankfurt. Franziska Martensen, she is a professor of political theory and the history of ideas and chairman of the board of the Center for the Global Cooperation Research at the University of Duisburg-Essen. And Hanne Meisner, who is a professor of interdisciplinary women and gender studies at the Center for Interdisciplinary Women and Gender Studies at the TU in Berlin, and myself. Published by Karl Alber Verlag, Law and Kritik, Recht and Kritik, the two names are equal, have equity, came out at the end of 2025. And we, the editors, wish to thank the Open Access Publication Fund of the University of Gießen, as well as the Center for Diversity, Media and Law for funding the open access publication. There is a link in the chat where you can also get the flyer. You can also ask for it afterwards. Law and Kritik, Recht und Kritik, explores what I would see as the ambivalent relationship between law and critique. This relationship, if anything, grew ever more contested during the period between we thought about the volume in 2022 and then ever more pressing political events, October 7th, the war in the Ukraine, causing people to take longer to think about or even to pull back their contributions given the political atmosphere. In the book, 29 authors quite in a very varied manner perform critique by employing, if I were to put it roughly, employing the law or legal argumentation or critiquing existing law. The majority of the contributors wrote in German, and I thank you for tolerating us in German, in English for the time being, and the inputs will be in English this evening. Again, we welcome both languages in the Q&A. In the essays, the contributors analyze connections between legal critique and critical reflection, law and social practices, and political movements, and law and autonomy. Whereas some contributors took decolonial, critical race theoretical, post-humanist, or anti-cis patriarchal perspectives on their subject, others discuss the need to defend the rule of law during democratic crises, like the one we are arguably in. The contradictions in existent legal systems and rights regimes are highlighted, as are processes of legal subjugation. Alternatively, law was understood by the contributors pluralistically and reconstructed using alternative means. Grounded research, the following topics emerged out of the 29 essays in the collection. That was historicizing law and critique. Peter will be speaking to that, or Peter. Theorizing legal criticism, critiquing existent law and human rights. Heide Gerstenberger will be speaking about that. Examining legal subjectivity and subjugation, and defending the rule of law during democratic crises. Ralph Grunewald will be speaking to that. And on the topic of pluralizing law, Gerlov van Englenhoven and Daria will be speaking. You can see we wrote all of these topics using the participle, the ing form, because they are happening. They haven't stopped occurring. They continue to evolve as we speak, as does the political nature of this topic. So I'll be asking the contributors either how did you approach law and critique in your own text, or more perhaps provocatively, is it possible to perform legal critique in our current political constellation? It's my pleasure, as for the first input, to introduce Peter Goodrich. He is professor of law at the Benjamin and Cardozo School of Law at Yeshiva University. He is also visiting professor at the School of Social Science, New York University and Abu Dhabi. Peter is the managing editor of Law and Literature and serves on the editorial board of Law and Critique. Extraordinarily well published, his latest publication is a Terspiskorian and theatrical collection, Performing Law, which will be out this month with Cambridge University Press. He has an affinity for the silent P in a number of words that I cannot pronounce, and he also has a penchant for wonderful and provocative performativity. Welcome, Peter.
Well, a Tyrannophile Scytherism of a Ptomaine, Ptarmiganian propensity of positivities to you, and delighted to see you, and thrilled, lost in America, isolated in the United States, with only Simon Stern as a friend across the howling gaps of the Canadian-American border. Critique is something of the past. It is, the word of the day is salostalgia, which is a retrospective recollection of nostalgia. But my contribution was, in many senses, triggered by that biographical memory, by the cycles of critique and the Nietzschean eternal return of the same in always different forms. So I'll talk a little bit about that, but first off, I never tire of puns and of anagrams. So Greta is an anagram of great, and it's fantastic that Europe is still producing critique of this sort, and that she is as indefatigable and as didactically virulent as she continues to be. Always a lesson and always a pleasure. Such aside, when we founded the journal Law and Critique, we obviously failed to copyright the expression itself. And so I'm very glad that Greta was able to use it. And of course, that is my sense of humor, because to proselytize, to critique, to engender, and to continue in the perpetuum mobile of the community of thought is obviously to share and to hold all ideas in common. So what's my story and what's my relationship to critique as an exile from the Brit crit tradition, and as someone lodged in a hostile increasingly lucifugus environment. And I'd go back to where we started and to how I think that there are in the new generation and in the morphing from historical materialism to new materialism and expansion and openness and environmental and a communitarian trajectory, I hesitate to say advanced, but a novelty, and how that novelty should be supported by those titans of critical thought, such as Adil Hussein and Sabrish Suresh, who are joining us from distant parts and climes, and also Gibran Mansour. So when I started out, there were two themes in the emergent critical legal thought of the post-60s, which is to say late 70s, early 80s generation. The first was affective and anarchistic in a loose, but then anarchism defies definition, emotive sense. So Feyerabend in Against Method has this extraordinary expression that it is constantly surprising the extent to which professional anarchists, yes, professional anarchists, which is to say epistemological anarchists, never question the stultifying effect of the laws of thought, or the capital L laws of theory, in their practice, how they accede, in other words, to a series of legislative strictures about what constitutes the ratiocinative process, and how in their practice they are constrained by that and expel the sense of chance and accident and pataphysical imagination that have, in scientific terms, engendered the most important and obviously paradigm-shifting discoveries. And that affective, anarchistic epistemology, I think, was the emotional basis of the Oedipal rage, or the critical sensibility that we brought to an establishment that was tired and sclerotic in many senses, in a mode of repetition. The other work at that time was Thomas Matheson's Politics of Abolition, because we all were in some sense utopians, and he had the theory of the unfinished, which seemed to be an application of Feyerabend's Against Method, resistance to the stultifying effect of the laws of thought. In Politics of Abolition, his argument is basically that abolition has to be total. In other words, it has to be unfinished, without program, without rules or plan, because the moment you have a plan and a program and compete with the extant social structures, you are constrained by them, and you are constricted by virtue of what comes along in the background as the hidden plan. So you basically substitute, and it ends up as a mode of repetition, whereas the unfinished, abolition properly so speaking, would involve competition that contradicted extant structures, that was unfinished in the sense of not being, in that dual sense, finished. In other words, that was open to such an extent that it could not be constrained by the pre-existent and substitutive forms that the social system provides. So those are kind of an anarchistic utopian ethos in which we really believed that the revolution would come in our happy little bubbles, and that things would be, so utterly different that contemporary discourse and conversation was really of no value. Then the other theme and nothing like a good contradiction, was of course historical materialism, that we all grew up with the notion that history determines consciousness, not consciousness history. And in other words, the concept of abolition that was predicated upon ignoring the extant institutional, regulative and governmental forms was simply idealism, ideology, escapism, and evasion of the fact that the reproduction of social forms and the institutional constitution of juridical and social roles, symbolic life, are all determined by the mode of reproduction of social forms. And so that tension prompted a strange inauthenticity or distance from the institutional and the regulative modalities that were extant at the time. In other words, the anarchistic, freedom-loving, affectively imbued and embedded sense of wanting something better produces a nebulous, but at the same time imaginative, enthusiastic, affectively engaged set of imaginations that, just as Feyerabend had pointed out, can produce radical and, in many senses, attractive options in thought, in theoretical practice, as we used to call it. But the historical materialist element of critique limits change to the ability to deal with the most successful system of social reproduction that the world has ever known, the extraordinary complexity and genius of market relations. And the only meaningful form of critique is to start with what's there and to deal with those modes of social reproduction as they exist. So critical legal studies expanded in terms of feminist legal theory, in terms of critical race theory, and now in terms of Anthropocene and neo-materialist theory. But the danger, and Nicole Wright talks about this in her piece, is of silos, of what Sloterdijk talks about in terms of spheres or boules, and what Francois Cosset talks about in terms of the utopian bubble of the American college and the American university as off-world sites in which you are transported into a species of outer space for 4 years and then return drugged on lacanium and deridium, although perhaps less so now, to the contemporary institution. But that's to say that critical theory suffered from its distance from any extant practice. And it suffered also from a distance from the scholar's own practice, in the sense that I think the next kind of scission is between theoretical elaboration, books on theory, articles in law reviews that take remarkably radical stances, but in the classroom, outside of a few electives, it's increasingly the case that none of that plays into the casebook that you use or the doctrine and dogma that gets reproduced, not least because that's what the students, the clients, are wanting. So, as Corsten points out, the neo-materialist is trying to reconnect. The cycle goes around. If our consciousness is determined by history, things haven't got much better. In other words, social circumstances and the mode of social reproduction has exponentially expanded, but has not greatly improved in the senses of freedom of thought, in the senses of equality of persons, in the senses of distributive equality that the historical materialist and the anarchist, the affective drive of critique has been looking for. So to me, the most exciting aspect of the return of materialism in its expanded environmental form is trying to burst the pedagogic bubble, is trying to engage the critical theory in the political practice of scholars, which is teaching the next generation of students. Jurisprudence, as Deleuze says, is what writes the law. And if cognizant of that, then the cases you choose, the mode of analysis that you utilize, and the willingness to listen. And I think the neo-materialist principle is classically just. Audi autorem partem should probably be pluralized, but listen to the other side and expand to realizing that the other side incorporates the third that is lodged as the subject matter. So I'm very keen on what's called the Wild Judgments Project. In other words, look at each of the cases in terms of the subject affective, be that subject a river, a farm, an animal, a herd, a shoal, a flock, a forest. In other words, everything thinks is the basic premise. And to think with the expanded neo-material environmental context of any judgment is to take seriously, which is to say to give time to and to hear those subjects impacted by those contexts within which legal regulation performs, and the ability and the willingness in our Anthropocene and Novocene context to attend to that is, I think, at one level, or in my context, the most critical role that the theorist can play, and the extimate fashion in which they can engage with, think with, and appreciate the sensibility of those that are impacted by the laws that we teach, that we manage, that we reproduce. And so if the subject matter is wool, if it's a roof, if it is a fish, you need a piscine epistemology, you need a sartorial epistemology, or you need an architectural epistemology to try and come to terms with and understand the immanent basis of what are, after all, simply superimpositions or the epiphenomenon of legal rules. With that, and I've no idea how long I was supposed to speak. I can go on endlessly. I can be very brief, but I'm going to stop at that point because I would say it all again in German, but I can't.
Thank you, Peter. Thank you so much. Okay, I'd like to introduce our second speaker, and I've asked if we could, Heide Gerstenberger was kind enough to speak in English this evening, although she wrote in German, and I've asked one of my colleagues if we could maybe show a picture of her so we can imagine whom we're hearing. Wonderful, thank you. Frau Gerstenberger, wir freuen uns. Heide Gerstenberger is Professor Emeriti of Theory of State and Society. We'll wrap our brains around that at the University of Bremen. Her research was and still is just as broad in scope as the name of her professorship. She has, for example, researched the work of seafarers and the transformation of this work in the era of globalization. However, the analysis of historical developments and the current reality of state power remains at the heart of her work. Thank you for being here, Frau Gerstenberger.
Can you hear me? Oh, heavens.
We can now.
You can now.
Yep.
Okay. I'm so sorry I didn't manage the camera. That's without old people. Okay, my contribution is totally different from Peter's. Bourgeois revolutionaries fought against state-sanctioned differences of social status, and they declared that basic human rights should not be open to political alteration. That slavery was abolished in France in 1792 was consistent with this revolutionary impetus. Its re-establishment in French colonies only 10 years later announced that henceforth the right to private property was to be privileged over all other civic rights. Together with slavery, the Code Noir of 1685 came back in force. Such a code, the French was not the only one, was an instrument for the political strategy which specialists of modern colonialism have come to term lawfare, meaning that law was made use of in order to stabilize a situation of dominance which had been achieved by warfare. Rights were to be granted or denied on the basis of birth. If the exportation of the principles of common law to English colonies did pose certain problems, the introduction of legal procedures did not result in de facto equality before the law. That lawfare could also be practiced in parliamentary democracies was to become blatantly evident when courts in the southern states of the United States assisted former owners of slaves in establishing unfree wage labor by abandoning heretofore dominant interpretations of contract law. When black codes criminalized any form of paid labor outside of agriculture and vagrancy laws restricted access to labor markets, the freedom of contracting, which had long been considered a cornerstone of liberty, was transformed into a trap for black people. In the 1870s, courts came to interpret labor relations as relations of debt, therefore making it a criminal act to not complete an undesired labor contract. If peonage relations, as they came to be termed, were formulated as applying to anybody, they were usually not applied to white laborers. This started to change in the 1920s, when more and more immigrant laborers came to work under conditions of peonage. It was only in the middle of the 20th century that courts in the United States no longer made use of obligation law to restrict the liberty of contracting the conditions of one's wage labor. Today, legal restrictions to contract such conditions exist in many countries, not only, but especially for non-citizens of the respective states. And then there are those spheres of law which, in spite of being located onshore, have become known as offshore spheres of law. In order to attract foreign investors, governments offer specific conditions for financial services. They create export processing zones for specific labor conditions, and they offer flags of convenience. None of these new flag states regulate the crewing of their ships, meaning that it is legal for shipping companies to not only hire the members of their crews anywhere in the world, but to also pay them according to the conditions in their respective home countries. In the 1990s, fierce competition on the world market of freight induced governments of traditionally leading shipping industry to also offer the growing conditions of flags of convenience by creating so-called international registers. In fighting against the creation of such a register in Germany, the competent trade union and the two northern German states demanded a judicial review procedure from the Constitutional Court. The Second Senate argued that in order to create incentives for shipping companies to manage their ships under a German flag, the rights of seafarers needed to be reduced. The judges seem to have been convinced that a nation needs to have a national merchant fleet. In other words, sovereignty, or to be more precise, a debatable interpretation of its preconditions, is to be valued above social rights. Thank you.
Thank you so much, Frau Gerstenberger, also for your generosity in speaking in English this evening, for us here in Germany this evening. It is now my great pleasure to introduce another contributor to the book. Gerlov van Englenhoven is assistant professor at the Leiden University Center for the Arts and Society, specializing in post-colonial memory, intangible heritage in diaspora communities, and decolonial cultural work in the Netherlands. He is currently running a 4-year participatory research project called Listening to Silence, in which he interviews and collaborates with decolonial artists, curators, and activists on the active use of silence in their practice. He has a video podcast series, which I strongly recommend on the topic, on the YouTube called Listening to Silence, and another video podcast series called Unboxing, made in collaboration with his own community's museum, Museum Maluko in The Hague. Welcome, Gerlov.
Thank you, Greta. Sorry. Thank you, everyone, for being here. The children are in a different room making sounds, so I hope you can't hear them. I sure can, and it is doing something to my concentration level, so I'm going to do my best. I'm going to do my best to keep it short. My contribution is about a phenomenon called adat, which is a legal-esque cultural phenomenon in Indonesia, as well as in the Indonesian diaspora communities in the Netherlands. In the Netherlands, in our communities, the way we use it, adat, is basically to refer to traditions, customs, anything that has to do with marriage rituals, spirituality, ways in which we stand in relation to the environment and to ancestors and you name it, but also just customs. How do you treat guests, for example? But in Indonesia, there is a more strictly legal relation as well. Adat has a more indigenous law type function in Indonesia in different ways in different parts of Indonesia. And it is, for example, about land ownership, about clan representation, indeed about marriage rules and other forms of law and politics on the ground, indigenous law, indigenous knowledge. And my short contribution kind of uses the weird history of adat laws, specifically in relation to Dutch colonialism in the early 20th century, as a kind of an allegory, if you will, of what I would think is the purpose of the critique of law. And it's all about legal pluralism. So briefly about adat, and then straight to my understanding of the critique of law based on this. Adat the term is Arabic, and it means habit or custom. It was introduced in the territory that we now call Indonesia by Islamic merchants in the 13th century, more or less. And they would refer to traditions, local traditions, as adat, so habit or custom, whenever these traditions would not be correct according to Islamic law or hukum. So if it wouldn't fit in Islamic law, but it was harmless, let's say, it wouldn't threaten Islamic law too much, they would tolerate it outside of the scope of the law and call it adat, which means that it's basically not a thing per se, It's not one thing that you can classify as something or codify in whatever way, because it's an umbrella term of everything that is about rules and regulations, but it's not official law. And it has survived in that way for centuries, and also several different histories of colonization, because the territory has been faced with colonization by the Spanish, by the Portuguese, the British, and from the 17th century onwards also the Dutch, most importantly the Dutch. And very often, and there's other articles where I write about this in depth, often what they would call Adat, indigenous people on the ground, let's say, it would be specifically organized against colonial rule. So that means that Adat would also morph into everything that would upset the colonial logic of law, let's say, which means that very often it was a response to whatever was the colonial law at the moment, or the oppressive law. Now, in the early 20th century, something really interesting happened. A man called Cornelis van Vollenhoven, a Dutch legal scholar in the early 20th century, he tried to do the impossible. He tried to codify Adat into Dutch colonial law. So he tried to do it in such a way that he wouldn't destroy the flexibility of Adat and the situationality and positionality and relationality and multiplicity of Adat, but he would still try to codify it. And that was in a way an insane plan, and he was also seen as such in the early 20th century. He was a very controversial figure. People called him a hopeless romantic, and those were the more nicer kind of labels that he was given. He would often write open letters to Dutch legislators in the court as such, manifesto-like, explaining why the way in which they understood local law in the colony was completely ridiculous, and he would take a very kind of antagonistic tone with this. Meanwhile, he would write almost 100 books on Adat law, having multiple, what we now would call PhD students everywhere in the territory doing field work and trying to understand what everything that Adat could be, while meanwhile it was changing all the time. So he would also have ludicrous or kind of really complex suggestions where he would say, for example, we would have to codify all of Adat, and then every 10 or 15 years we would have to reset it completely, throw all the books away and start writing anew, because in 10, 15 years in the new generation everything is new now. Adat is now completely something else, and all the work we've done so far is useless. So I find him a very interesting person. Historically speaking, he was basically someone who tried to do legal pluralism in a very honest, genuine way. He plays a very strange, ambivalent role in terms of what his relationship was to colonization as an ideology, and also a superiority or hierarchy related way of power, because it was unclear whether he was an ally trying to kind of work towards autonomy, or whether he was trying to find a very systematic way of codifying that which was not codifiable still into the Dutch law, and in a kind of repressive tolerant type of way, as Herbert Marcuse would say, where it would be tolerated, but as long as it would still, as long as the Dutch would still be in charge of it. Now, in the short article, what I try to do with this is I try to understand how Van Vollenhoven is trying to wrap his head around this concept, which is situational. He's trying to explain what Adat is in endless books, meanwhile trying to do justice to the fact that it's always changing. So I use several big names in legal philosophy like Derrida and Benjamin and Greta, Olson and Deleuze as kind of people to understand what he's doing. Now, Greta Olson, as you all know, wrote a lot about law and affect and legality. And I think one thing that Cornelis van Vollenhoven was an early connoisseur of was that there is an affective dimension of Adat. Adat is not something that is, but it is something that does. Adat does something to people in terms of their sense of justice, or their rechtsgevoel, as Greta calls it, the adjuring. So that's, I think, what he's doing. He's seeing that there is a kind of underground performance of law and an embodied experience of law that can therefore, because of the way in which it is, it cannot be universalized or codified into actual law. And in the article I say this is actually not as niche as it may sound when I take the case study of Adat in a colonial context in Indonesia. This is a basic problem of justice as such. This is the way in which Derrida and Benjamin and Werner Hamacher are also writing about it. Hamacher, for example, writes in the 90s already, laws require universality. Justice, however, consists essentially in being adjusted to suit situations. Therefore, just ends always apply to one singular situation alone, which is why only singular laws may be regarded as just. Only singular laws may be regarded as just. And Jacques Derrida, also in The Mystical Origin of Authority, says justice is an aporia, so a vanishing point of law, something that we always imagine to be there in the future, or something that we find in the moment, but then it's already over, and then we can refer to it as a moment that happened in the past. But to kind of standardize it is an impossibility, because the fact that justice is an embodied experience that happens in relation to things that happen. So following Deleuze and following the way in which Van Vollenhoven instinctively seems to have related himself to Adat, I argue in the text that we shouldn't think in essentialist terms about law and justice, like what is it or what should it be, but we should think of it in the multiplicity type of sense. We should think in the contextual sense, what we should think, whose law are we talking about, and for whom, where is justice taking place, under which circumstances, why are people feeling that there is justice or there is no justice, whose justice are we talking about, in which particular era are we looking. And then to conclude, so to me, the critique of law is this: the pursuit of law's limits. It's the ongoing reflection on law's successes and shortcomings in order to improve it and bring it closer to the needs of a given society. To critique law is thus to approach it as multiplicity and in context. It's not to explore what it is or what it should be, but to explore who is shaping it, who is executing it on behalf of whom, and in defiance of whom, for which reasons, under which circumstances. Finally, it is to become receptive of law's affective dimensions, meaning what does law do to people and how, and what do people want from the law and why. Thank you.
Thank you so much, Gerlov. Really wonderful also for others to learn more about your work, a pleasure I've had for some time. As our next speaker, and I want to compliment him because he raced from class and other activities to be with us in a punctual way, showing his binational and bicultural wonderful habitus, is Ralph Grunewald. He is Associate Professor in the Department of English and the Center for Law, Society and Justice at the University of Wisconsin at Madison. He received his law degree and PhD in criminal law and criminology from the University of Mainz in Germany. After his second Staatsexamen, I have difficulty saying it in English, state exam in Nuremberg, Ralph came to the United States for a master's degree and LLM at the University of Wisconsin at Madison's Law School, where he worked with the Innocence Project. This ignited his interest in comparative law and legal narratology, which is now the focus of his work. Also that of Simon Stan, who I'm happy to see is here as well. Welcome, Ralph.
Thank you. Guten Abend nach Deutschland. Schön ein paar bekannte Gesichter. So thank you so much, Greta, for the invitation. And so my approach to this was at the beginning, I was quite hesitant when Greta reached out and asked me, would you be willing to contribute something about to this volume? And because she mentioned you can't use any footnotes, preferably no footnotes. And I said, I'll say what? How am I not in my good German legal manner? How can I do have to prove my points? And so this really started a reflective process on how I'm thinking legally, what informs my own legal consciousness. And I see Birte, and I see Markus Dupper and many others who work, and Greta, you of course as well, work in this kind of multicultural legal sphere in which we kind of are steeped in one area of law and one culture of law with, as Peter Goodrich said, with historical foundations, right, that are informing our thinking, and now we apply them to a different field. It's kind of made me even more self-conscious than I usually am. But took the challenge, and I just kind of internalized and thought, like, so what is it that really bugs me about the law? So what's happening right now that really strikes me as odd, and where do I have kind of an internal conflict? And this is kind of the beginning of my of this project. And of course, that anyone, as I saw in all the wonderful contributions, anyone picking up this topic, even if I gave you the same content and cases I was looking at, there's, no inter-rater reliability. So you would come up with something completely different. So what I did is just basically me passing through a couple of things, and that stuck with me. So in my contribution, I confronted myself with the question of legitimacy of law and what can the role of law be at times of abuse of power. And this is kind of what struck me. And this is when Greta brought this up, I was listening and hearing and reading things with this filter on, sometimes even unconsciously. So what I do in my piece is that I argue that legitimacy of law rests primarily on the predictable and consistent and restrained application of existing law. So when courts abandon this mundane task, legal certainty and with it the rule of law itself begins to erode. And I want to structure my thoughts in three ways. I'm going to go through 3 points how I built this argument. First, I was confronted and saw a phenomenon that made my German legal heart ache a little, the everyday expansion of legal liability in the United States. And then I saw this in conflict with promises of constancy and predictability that law has. So I tried to kind of resolve this. And then, I went to and looked at the law struggle with power itself. So my contribution begins with a case that I've discussed multiple times in class. It's the case of Commonwealth versus Carter from 2016. That's the case in which that I would think would have gone completely unnoticed had it not been for its striking narrative. Michelle Carter, young woman, 16, 17, was convicted of involuntary manslaughter for encouraging her boyfriend, Conrad Roy, to commit suicide through text messages. So not the suicide through text messages, but encouraging him to commit suicide by using text messages. So at a critical moment, when Conrad had already kind of put himself into a situation of committing suicide in his car, he exited his carbon monoxide-filled vehicle, and Carter told him to go back inside the car. He did, and he died shortly thereafter. So what made this case legally extraordinary was not the tragic narrative, actually. It was what triggered the case, why it kind of, where courts took it so seriously, but it's doctrinal novelty. There is no Massachusetts statute criminalizing assisted suicide. In existing criminal law, doctrine traditionally treats suicide as the act of the person who dies and not third parties who merely influence them, assisted suicide laws aside. Causation doctrine generally requires that the defendant's conduct approximate cause of death, words alone usually don't suffice for that. Nevertheless, the court found that Carter had created a self-created duty to intervene and that her failure to do so constituted wanton and reckless conduct. And this amounts to, in my eyes, and to a retraction of criminal liability unconstitutional statute or precedent. This is not, I would say, one poorly argued case. It somehow exemplifies a systematic problem that is at stake, and that's legal certainty. Supreme Court early on, 1930s, said that law must provide a fair warning in language that's the common word will understand of what the law intends to do if a certain line is passed. And to make the warning fair, it has to be possible for everyone to understand it. Or, and now the kind of, the comparative heart comes in or mind. As Gustav Radbruch put it, justice requires that law be certain, ensure that it is not be interpreted and applied one way here, now another way elsewhere, and tomorrow. But Carter is not an outlier. Similar expansions to criminal liability can be seen in recent prosecutions of parents for school shootings, where courts again stretched causation doctrines to satisfy a social demand for accountability. These are cases in which parents are charged with homicides for school shootings their children committed. On the constitution level, we see a different kind of branch of expanding or kind of diminishing certainty. In Planned Parenthood versus Casey, it's the case from 1992, the Supreme Court famously declined to overrule Roe versus Wade, not because every justice agreed with abortion rights. They didn't. But because legal stability mattered more than individual conviction. The court emphasized that a promise of constancy once given binds the court. Because the rule of law depends on people being able to rely on settled expectations. Justice Souter described adherence to precedent as essential to the court's mundane task. This is where the title comes from, the mundane task of any legal system to realize our hope for a stable society aspiring to the rule of law and to a society governed by law rather than power. Dobbs, as we all know, in 2022 shattered that promise of constancy. Another example, now moving closer to the issue of power and law, it was power that Deputy Attorney General Emil Bove used to direct Daniel Sassoon, the United States Attorney for the Southern District of New York, to dismiss the indictment against the former mayor of New York City, Eric Adams. Bove stressed that prosecutors have a duty to make good faith arguments in support of the executive branch's position. As we know, Sassoon could not see any good faith basis for Bove's position and argued that impartial enforcement of the law is the bedrock of federal prosecutions and that the rule of law depends upon the even-handed administration of justice, insulated from political influence. So here now is the box is open and we have to ask ourselves, so what is the role of law in times of crisis? What's the role of law in the face of power? And I found answers in legal theory drawing pretty extensively on Rudolf von Jherin's 19th century text, The Struggle for Law. And for von Jhering, law is not an abstract ideal, but a living social force realized only through everyday practice. So, and to kind of complement this, if you don't know like the German jurisprudence, it's very often theories developed through cases. It's very pragmatic. It's even theorists will never try to lose kind of touch with the individual case. Von Jhering wrote that law is not merely theory, but living force, and that a legal principle that is never applied or that loses its force no longer deserves the name. The struggle for law is anchored in what might appear as counterintuitive, the concept of Rechtsgefühl, of a term that Greta knows inside out and can theorize about a lot. So it's a sense, the translation would be a sense or feeling of justice, the dissonance of the existing law and the sentiment of legal right. When the imperfection of legal institutions refuses the plaintiff or anyone satisfaction, the struggle for law becomes a struggle against the law. This is not license for judges to impose their own sense of justice. Its central purpose, von Jhering exists as the opposition to arbitrariness. Law must be applied even when the motives of the litigant are reprehensible. And then he gives the example of Shylock in The Merchant of Venice, where he says, even if his motives are hatred and revenge, you got to give him his law. Bias, this is a good example for it, rarely enters law openly. Instead, it becomes legalized through application and interpretation. Courts can, as von Jhering warned, force foreign presuppositions into law through what he mockingly called a dialectical interpretation press, through which one extracts from the law what we want and what we need for our purposes of power. And so force takes the shape of law. The danger is not lawlessness, but lawful-looking arbitrariness. And those who live in Germany, and especially during the pandemic, you might have heard the term Quatschjura, which is legal nonsense used to force someone's hand. It's the method of referring to law that actually is no law, to say that, for instance, the right of someone who owns a shop to, allow people to come in without masks when there is actually a mandate to wear a mask. So it's called Quatschjura or nonsense-jura. The dialectical, so this is how the forms law can take legal arguments that appear authoritative but lack substance or a basis in actual law. So now in closing, legal systems collapse not only when officials openly defy the law, but when judges and prosecutors lack the courage to insist on legal validity over moral fervor or political pressure. As von Jhering wrote, without resistance to what is unjust, the law would deny itself. The true task of courts is therefore modest but indispensable: to apply law predictably resist arbitrariness and preserve the conditions under which citizens, especially those at the margins of society, can anticipate the consequences of their actions. When their task is neglected, the promise of legal certainty vanishes and law risks becoming a mockery and a word without meaning. Thank you.
Thank you so much.
Yeah.
As our last and certainly not least input and speaker, I'd like to introduce Daria Bayer. She is a postdoctoral researcher in criminal law and legal philosophy at the Martin Luther University of Halle-Wittenberg and currently a visiting scholar at Leuphana University in Lüneburg. Her work situates criminal law within broader currents of legal critique, engaging interdisciplinary perspectives on legality and affect. As a founder of the legal theater collective, KIF, she explores how dissolving the boundaries between law and theater can open new ways of understanding law, democracy, and community. Welcome, Daria.
Thank you so much, Greta, for inviting me to speak today at this book launch. I will turn on my camera in a second. My baby just decided to eat right now at this moment, so childcare seems to be the second theme of the night. Yeah, now we're done. But still, I will try to do my best.
And we'll just, if I may say, grandmother that I am, we welcome your baby and do not mind sounds. It's wonderfully real and material and beautiful that your child is with you.
Thank you, thank you. I just have to keep her from crawling to the switch off of the computer, which is the favorite thing to do. So this text is very dear to me because it reflects my own journey between law, critique, and artistic practice. And it also is my personal response to the question that Greta raised at the beginning of this book launch. Is critique of law still possible in those times we have? Or should we not simply do everything to protect kind of the achievements we have? And well, I believe, of course, the answer is yes. We still can criticize the law. And I hope to give some ideas why I think so. Let me begin with a few words about how this text came into being, because that is also part of my answer. And when I wrote this text first, it was 2022, in the midst of preparing for my second bar exam, and I conceived it as a classical academic essay. It was meant to summarize the key insights from my PhD, where I engaged with a Marxistic critique of law and explored how theater can make visible the foundational structures of law and open them up to transformation. The text was finished, edited, and submitted in 2022, and I kind of crossed it off my to-do list. And then 2 years later, Jochen Bung mentioned that this book took a long time, which was good for me, because 2 years later, I was invited to a research series, Terms and Conditions, the legal form of images, at the Harun Faraki Institute at the University for Fine Arts in Leipzig. And there I began to see law differently. I began to have kind of a new perspective on law and to see law as not only as a regulator, but also as a catalyst for art. And what do I mean by that? So for the artist's presence, law provides, of course, the frame within which art takes place. And especially in times of rising authoritarianism, that frame has become more restrictive. And at the same time, I could sense there that because of those restrictions, law had become increasingly interesting to artists as an object of artistic practice. So artists increasingly engaged with the law and also with legal theorists such as Pashukanis in order to kind of be part of it, to reshape the law, and in doing so, in a sense, to remaster the law that they feared. And this presence of fear is what struck me most, not only in Leipzig, but also in Weimar, where I was invited a few weeks later at the Bauhaus University, together with my colleague Lucia Samara for the Good Practice Salon, the Department of Art and Research. And there again, I encountered a very real anxiety about the future, not only fear of increasing restrictions, but of funding cuts, which are also happening. There are also professors who lost their jobs now, of political interference, of losing institutional autonomy. And within that fear, law appeared almost as a source of hope, the hope that the law could protect existing structures, protect what we have. And this kind of changed my perspective, because working within the law, I often lose sight of how law appears from the outside as something that frames our actions, but is also shaped by them. A house, to use the image of Audre Lorde, that is constantly being constructed and reconstructed. But for reconstruction, and that is kind of what we're doing when we're criticizing the law, we need, of course, a stable foundation. Because without foundation, we cannot reconstruct. And right now, it seems that it is that foundation that is under pressure. And I don't have to expand on why this foundation is under pressure here. But when we ask about should we not rather protect this foundation than thinking about imagining another construction for this house, we must ask, what is it that we want to protect? Because, of course, as we all know, that already those foundations we are thinking about protecting, they were never as stable as we think. They have always contained exclusions and blind spots. So if we, in those times, just retrace to protection and not engage with imagination, we can't change anything. We are just living again in the same fundament. So I think it is not only about defending the existing house, but again, reconstruction is necessary because it's already happening. And then reconstruction becomes necessary. It's not a luxury, but it's necessary in the crisis. And the crucial question that we can ask here is, who is doing that reconstruction process? Because again, there is a lot of people trying to reconstruct the house, but who is engaging in it? And I think it is there where we can have a real impact and where imagination matters. Because in times of authoritarianism, as we all know, imagination is often suppressed because it challenges what exists and opens up new perspectives to think about what could also be. And we know artistic practices like film, performance, and theater can allow us to see law as contingent, as something that could be otherwise. But at the same time, we should not romanticize the arts and say, oh, the arts will save us, but rather we can see the law itself as being modeled by us, the lawyers, and part of that reconstruction process. So I think, how can we remain optimistic? It's not by assuming that everything will turn out well at the end, but it's rather to just continue doing the work we've always done, even when the outcome is unclear. The key, I think, or at least for me, was just to try things out and to be consistent with it, consistent in trying. Because, as I said, the house of law is already being reshaped, but we shouldn't let others do the reconstruction without us. So I want to close my short remarks by returning to the text itself that you can find in the book. After my visits to Leipzig and Weimar, I decided to completely rewrite it, and not to change its core ideas, but to change its form and perspective. And I moved away from a purely academic style toward a more essayistic first-person approach. And of course, the shift is not new or original. There's a lot of autofictional writing at the moment happening in philosophy, which is a really popular movement. But that is not the point. It was just the point to be consistent in attempting to try something new. And with that, I want to end. Thank you so much for having me.
Thank you so much, dear Daria. Before I finish or we close the recorded part, I'd like to sincerely thank the 5 speakers. I'll do this with English informality. Peter, Heidi, and Gerlov, and Ralph, and Daria and her daughter, who is with us as well. And I'd also like to specifically thank Felix von Groningen, who is helping in the background. And more specifically, I'd like to thank Laura Goller, whom you can see but not hear because she's in the silent part of the library. Laura is a PhD in migration law here at the University of Gießen, and her help was invaluable in particularly with the German essays, choosing the which sentence we should translate and concentrate, and also testing, counter-testing my syntheses of the essays. So I really wish to thank her explicitly before we go on.